by redistribution of territory of a state or by uniting two or more states or parts of states or by uniting any territory to a part of the state, increase the area of any state, diminish, etc. But then four lines from thereafter, parliament. The word starts with parliament. Parliament is therefore by law invested with authority to alter the boundaries of any state and to diminish its area so as even to destroy a state with all its power and authority. That being the extent of the power of parliament, it would be difficult to hold that the parliament which is competent to destroy a state is on account of some assumption as to absolute sovereignty of the state incompetent effectively to acquire by legislation designed for the purpose of property owned by the state for government purposes. Then next is, Manoj, again, Babulal Parate is 5 judgment. Babulal Parate, this is different, Manoj, not that 19(1)A judgment. That is also Babulal Parate, my lords, recollect, my lord, freedom of speech and expression. Lord, here, views, my lord, the assembly's views were taken from Bombay Assembly for ABCDE areas. And when the Reorganization Act, Act was passed, Lord, it was some additional areas were also, Lord, therefore that was under challenge. We proceed now to consider these contentions. It is necessary to state at the outset that our task is to determine on a proper construction the true scope and effect of Article 3 of the Constitution with particular reference to second condition laid down by the proviso thereto. We bring it to our task such consideration as are germane to the interpretation of an organic instrument like the Constitution, but it will be improper to import into the question of construction doctrine of democratic theory and practice obtaining in other countries unrelated to the tenor, scheme and words of the provision which we have to construe. Lord, kindly come to the later part, my lord. Article 1 of our Constitution, Lord, somewhere in the 10th line from bottom of 170. Does your lordship get me?
Yes.
Article 1 of our Constitution says that India is a union of states and the states and the territories thereof are specified in the schedule. There is therefore no difficulty in understanding what it meant by expression state in Article 3. It obviously refers to states in the first schedule and the legislature of state refers to the legislature which each has under Constitution. That being the position, we see no reason for importing into the construction of Article 3 any doctrine, consideration of the sanctity of rights of states, or even for giving an extended meaning to the expression state occurring therein. None of the constituent units of Indian Union was sovereign and independent in the sense the American colonies or Swiss cantons were before they formed their federal unions. The Constituent Assembly of India, deriving its power from the sovereign people, was unfettered by any previous commitment in evolving a constitutional pattern suitable to the genius and requirement of the Indian people as a whole. Unlike some other federal legislatures, Parliament, representing the people of India as a whole, has been vested with the exclusive power of admitting or establishing new states, increasing or diminishing the area of an existing state, or altering its boundaries, the legislature or legislatures of the states concerned having only the right to an expression of views on the proposals. It is significant that for making such territorial adjustment, it is not necessary even to invoke the provisions governing constitutional amendments. Then, my lord, Raja Rampal, only one line, my lord, I'll now coming down to one line, my lord, kindly, my lord, appreciate. It says India is an indestructible union of destructible units. Raja Rampal, my lord, again, 5-judge bench. Law, my lord, I am pointing out. I am not pitching that argument that high, my lord. What we have done is, as a temporary measure, as it is clear from day one, the parliamentary debates, that we have created two units, namely two union territories, and one union territory is with legislature, the power vested with the power of police with the center. Because of the very peculiar nature of the situation arising since decades. Rest everything they have, what state has.
Pointed out two instances where it has happened. First was Punjab. That was a very peculiar problem. Punjabi Suba movement, etc. More or less everybody was agreeable to not muster through the legislative assembly.
No, there was no assembly.
It
was during governor's rule.
No, I understand that, but earlier it could not muster through the division of Punjab between Haryana and then parts of Punjab going to a union territory first, even Himachal Pradesh, then Himachal Pradesh itself becoming a state. And then probably Cochin and Travancore is the other example which is given. The third is this. This is a way, because once you suspend the proviso, then virtually the power of the state governments are taken away. The representation of the state is represented by the will of the people of the larger country.
Correct.
Can lead to...
That is, my lord, touched upon in Bomai, S.R. Bomai. My lord, please come to page 173. Even this question was, my lord, considered in Bomai judgment. We read Bomai judgment for a different issue. But this was also one of the considerations, one of the factors which fell for consideration of the court. Page 173. Where the court considers what is the scope and ambit of the state's views. That's why I'll, rather than paraphrasing, I'll read. Lord, kindly see S.R. Bromai, para 108. Lord, para 108, my Lord, just is called page 173. I have quoted S.R. Bromai. Lord, last 4 lines on that para. But I'm trying to rush, my Lord, so that I can finish. Your Lordship gets on a conjoint reading, my Lord. My Lord Justice Khanna gets on a my Lord Justice Suryakant and yes. On a conjoint reading of these articles, it becomes clear that Parliament has the right to form new states, alter existing states, or the name of any existing state. Thus, the Constitution permits changes in the territorial limits of the states and does not guarantee their territorial integrity. Even names can be changed. Under Article 2, it is left to Parliament to determine the terms and conditions on which it may admit any area into the Union or establish new states. In doing so, it has not to seek the concurrence of the state whose area, boundary, or name is likely to be affected by the people. All that the proviso to Article 3 requires is that such cases the President shall refer the bill to the legislature of the states concerned, likely to be affected, to express their views. Once the views of the states are known, it is left to Parliament to decide on the proposed changes. Please, my Lord, note, Parliament can, therefore, without the concurrence of the states or states concerned, change the boundaries of the state or increase or diminish its areas or change its name. These provisions show that in the matter of constitution of states, Parliament is paramount. This scheme substantially differs from the federal setup established in the United States of America. So, my Lord, it is in substance, in my respectful submission, said that it's a provision which is strict compliance is not insisted upon, provided there is a broader compliance, namely the entire nation, considering that this affects the nation as a whole. This situation doesn't affect the state only or neighboring states only. This affects the entire nation and therefore including the representatives of Jammu and Kashmir. Parliament and Rajya Sabha, Lok Sabha and Rajya Sabha have representatives of Jammu and Kashmir. Lord, these are my judgments on 3 and 4. Would your lordships like to have a bird's eye view of the act?
All right.
Lord, volume 3, documents, page 112. I won't take more than, my lord, 5 minutes to do this. I am, my lord, tempted to show this because nobody has shown, which could not have been my objection, but without showing several statements were made that we are reduced to nothing, everything is taken up. Therefore, my lord, it is my duty to point out just bird's eye view, my lord. Page 112.
Volume 3.
Volume 3, document volume 3, my lords. Page 112. Lord, please see definition, assembly constituency is defined 2C. It has all attributes of a state. It is state with UT with legislature, but all attributes of a state. Assembly constituency, your lordship gets 2C. Am I with your lordship?
Yes.
Then election commission 2D, then 2G, my lord, on the next page, 113. 2G, legislative assembly, J, population ratio and union territory. Please, my lord, see the formation of union territory of Ladakh without legislature. Then, my lord, formation of union territory of Jammu and Kashmir with legislature. Correct, my lords? Then come to, my lord, page 114. No reduction. My lord, they say that our representation in parliament is reduced. On and para 10. My lord, on and from the appointed date, there shall be allocated 5 seats to successor union territory of Jammu and Kashmir and 1 seat to union territory of Ladakh in the House of People. Earlier they had 6. Now it is 5 plus 1, 6. Then delimitation of I'm sorry.
That's section 10.
Section 10, my lords. My lord, the argument of Mr. C.U. Singh was that we have lost representation in parliament. Then somebody said that our seats are reduced. Lord, Mr. Nafde said the seats are reduced. It was 6 in total. Now it is 5 Jammu and Kashmir and 1 Ladakh. Then, my lord, 12. Every sitting member of the House of People representing a constituency which, on the appointed day by virtue of the provisions of section 10, stands allotted with or without alteration of boundaries to the successor union territory of Jammu and Kashmir or union territory of Ladakh, as the case may be, shall be deemed to have been elected to the House of People by that constituency as so allotted. So they continue as Lord Lok Sabha members. Then 13. All and from the appointed day, the provisions contained in Article 239A, which are applicable to Union Territory of Puducherry, shall also apply to the Union Territory of Jammu and Kashmir. So, my lord, now, my lord, this is amended. My lord, this is amended. What is placed is not amendment. My lord, I'll just place your lordship, my lord, the copies of the amended act. I'm not reading from this act, my lord, I'll give copies to the other side also. Because this has all the acts which are made applicable, which were not applicable, central acts, including beneficial legislation, and suitable amendments in the local acts. Local acts are retained if they are not repugnant to the central acts, with suitable modifications making them constitution compliant. Well, this is amended, section 13, because the argument was that now we can't vote. MLAs of Jammu and Kashmir cannot vote. Lord, at page 10, foot of the page, section 13. My Lord, Justice Gawai and Justice Suryakant has that. Page 10 of this book, my Lord. Amendment is in this book, therefore, my Lord, I'm. Page 10, right side, left side, top is the pagination. Section 13. on and from the appointed date, the provisions contained in Article 239A or any other article containing reference to elected members of the Legislative Assembly of the state, which are applicable to Union Territory of Puducherry, shall also apply to Union Territory of Jammu and Kashmir. So they can vote, my lord, wherever MLA is required to vote. In, for example, the example given by petitioner was presidential election. Then 14, my lords. Copies. Section 14. There shall be an administrator appointed under Article 239A of the Constitution for the Union Territory of Jammu and Kashmir and shall be designated as Lieutenant Governor. The total number of seats in the Legislative Assembly would be 107. Then, my lord, every entry except police. Police is, my lord, now for obvious reasons, my lord, I need not even explain why police is, my lord, directly under the control of the center. And clause 6, my lord, this comes for the first time. 14.6. This was never there. Seats shall be reserved for scheduled caste and scheduled tribes in the Legislative Assembly of the Union Territory of Jammu and Kashmir. This has come for the first time. Then come to, my lord, section 16. Lord, earlier only permanent residents could contest elections under section 16. I'm not inviting your lordship's attention to read it. Now, he should be a citizen of India. He need not be a permanent resident for being qualified to be elected, my lord, like any other state, my lord. My lord, please come to the relevant entry, my lord, the relevant section, my lord, is at page 119, bottom, section 32, extent of legislative power. Lord, subject to my answering your lordships about the election on, Lord, day after, when, Lord, in the morning. But
119 of your compilation or?
no, the act. That's volume 3, Lord, same act. I'm reading from the act, Lord. Page 119, section 32. Volume 3, document volume 3, Lord. The lordships have 32. Subject to the provisions of this act, the Legislative Assembly may make laws for the whole or any part of the Union Territory of Jammu and Kashmir with respect to any of the matters enumerated in state list, except the subjects mentioned at entry 1 and 2, namely public order and police, respectively, or the concurrent list in the 7th schedule to the Constitution, insofar as any such matter is applicable in relation to Union Territories. Then, my lord, 35, inconsistency between the laws, my lord, there is a provision. Special provision as to finance.
Follows the Delhi model. Delhi model.
Has land.
Delhi, of course, 1 and land. 1, 2 and 18 is carved out. Land is given to the state legislation.
No, land is not given.
Not given. Where is land accepting? Which provisions is land taken away?
Not here, not here. Here only police and public order.
Right.
Lord, in Delhi.
I thought you were saying land is also taken away.
No. In Delhi, it is public order, police.
And 1, 2 and 18.
1, 2 and 18. Your lordships, Lord, we have troubled your lordships for a long period, my lord, on that. I wanted to avoid that part, my lord, but it is
It's argued so many times that even 1, 2 and 18 is stuck like a mantra in the brain, you know. So.
But here, my lord, 18 is not there, my lord. It is only public order and police.
Yeah, public order and police.
And for, my lord, reasons obvious, the very object and purpose of reorganization is this. My lord, thereafter, there are financial bills provisions.
One more change. Parliament has competence on all the three lists.
That is because of 239AA. My lord, not, here it's not there.
So unlike a state legislature, in the case of union territories, like Delhi, for instance, Parliament can enact a legislation on any item.
No, that is because of 239AA.
Double A. But
Here-
I'm saying the same principle is followed here.
I don't think, my lord.
It is
Here, 239,
subsection 2, nothing in subsection 1 shall derogate from the powers of conferred on Parliament by the Constitution to make
yes.
respect to any matter for the union
So, my
territory.
lord, that 239AA provision is incorporated in the statute. Your lordships are right. My lord, there is a consolidation for consolidated fund, my lord, which Mr. C.U. Singh said it's taken away. Annual financial statements, audit by the CAG. My lord, this is an official language, my lord. For the first time, there is an official language, my lord. I wish this was pointed out to your lordships, my lord, while saying that we have been deprived of everything. It's just a UT. It is a state, my lord, for all purposes except these two entries. I'm not going into the minute details, my lord, but it's a Lord, Mr. C.U. Singh argued that the assets are also merged with Union of India.
Actually, nothing turns on it in this case. It's almost like trivia right now. But clause 2 says nothing in subsection 1, 32, shall derogate from the powers conferred on Parliament by the Constitution to make laws with respect to any matter for the Union Territory of Jammu and Kashmir or any part thereof. So this provision does not empower Parliament to make a law on the state list.
Like 239AA.
The provision comes in 246(4). 246(4) says
Yeah.
Parliament has power to make laws with respect to any matter for any part of the territory of India not included in a state, notwithstanding that such matter is a matter enumerated in the state law.
No, that is at par with everyone.
That's why, no, just as a matter of constitutional position, Parliament can enact a law on all the three lists for Jammu and Kashmir.
Even in absence of subsection 2, it could have.
That's right. That's Article 246(4).
Constitution operates.
That's a constitutional position.
So I am not reading, my lord. Mr. C.U. Singh, my lord, said that even the assets will go to, has gone to the central government. So there is a specific provision, apportionment of assets. Jammu and Kashmir assets remain with Jammu and Kashmir, and Ladakh assets went to Ladakh. That's how, my lord, whenever reorganization takes place, the things happen. Now, my lord, I may come to Article 356. But kindly come to my written submissions. And this is, my lord, the last part of my submissions, my lord. I have already crossed my time, my lord, but 142. Yes, my lord, I am placing it for your lordship's consideration. Lord, the governor's rule is in challenge, as I have pointed out, after 14 months.
Which PDF?
142, my lord. So my written submissions, 142. Volume 3, 142. The lordships have a chart, my lords.
Yes.
Now, what I have done is, I have mentioned the number of the petition with the name. prayer prayed for, and the grounds for challenging this proclamation. These are the only petitions and these are the only grounds in those petitions. The Lordships are aware, my Lord, how a constitutional act of imposition of governor's rule or president's rule is to be challenged, and what should be the averments. What was the material, sufficiency, this, that, another? Nothing, because it was done after 14 months, only as a corollary of challenging 5th and 6th of August action. I'm not reading, my Lord, the pleadings, but there are no pleadings. My Lord, that's all I am saying. Lord, now, Lord, I am not reading, but there are no pleadings that it is arbitrary, it is illegal, and therefore declare it to be a void. That's all, nothing, no pleadings. Only technically a prayer is there. That's what, Lord, they can argue. Therefore, they have made a prayer after 14 months without pleadings. Now, please come to, my Lord, 146 of this very note, my Lords. On the question, so this is again S.R. Bomai. I am on page 147. Lord, I am going fast. I've seen your Lordship's eyes looking at the clock, my Lord. I am also on the clock.
No, that's not, please don't have any such feeling.
On the lighter side, Lord, it's...
That eye goes to the clock just as a matter of training, that's all.
On the lighter side, Lord, I am saying so that...
not directed to that one, you also will. More than 22 years of training on this.
Exactly, more than 22 years of training. Mr. Solicitor, when we were judges of the Bombay High Court, we had a colleague who had come from Gujarat on transfer, a God's good person. So he had this specialization. We would meet outside the Chief Justice's chamber every morning. Just a little bit of camaraderie, and then we go to car. So every day, our colleague who had come from Gujarat would tell us how many more days there are to go back to the vacation.
Yes.
So,
Lord, it is said that
66 days left for the vacation.
Lord, it is like many other parts, Lord, it is said that a Gujarati can come out of Gujarat. Gujarat never comes out of him. we always... Lord, 146, last, my Lord, part, only underlying portion. 147. Bomai, my Lord, S.R. Bomai. This, my Lord, kindly read, my Lord, the canvas of the court's jurisdiction. In fact, once the issuance of proclamation is held valid, the scrutiny of the kind and degree of power used under the proclamation falls in a narrower compass. There is every risk and fear of the court undertaking upon itself the task of evaluating with fine scales and through its own lenses the comparative merits of one rather than the other measure. The court will thus travel unwittingly into the political arena and subject itself more readily to the charges of encroaching upon the policy making. The political thicket objections sticks more easily in such circumstances, although therefore on the language of Article 356(1), it is legal to hold that the President may exercise only some of the powers given to him. In practice, it may not always be easy to demonstrate the excessive use of power. Lord, why I am reading this, Mr. Sibal read the first part of it. Lord, his attention, my Lord, missed this last part. My Lord. Therefore, I am, for completion, this is the law, my Lord. Lord, kindly come to the next judgment, my lord, at page 148, State of Rajasthan versus Union of India. Lord, 7 honorable judges, my lord. Lord, the bold part, my lord. There is a part which is made bold. The learned counsel, your lordship gets, my lord. My lord Justice Gawai gets, my lord, the bold part. The learned counsel, appearing on behalf of the petitioners in the writ petitions, contended that it is clear from the provision enacted in Article 356, Clause 3, that the exercise of power by the President under Clause 1 is subject to the control of both houses of Parliament. The proclamation issued by the President under Article 356, Clause 1 would cease to be in force at the expiration of 2 months unless it is approved by both houses of Parliament. Prior to, my lord, it was 2 months. Houses of Parliament, and therefore no irretrievable action such as dissolution of the Legislative Assembly of the state can be taken by the President before the approval of both the Houses of Parliament is given to the proclamation. He also restricts that irretrievable action can be taken, but not before it is approved by both the houses. Otherwise, the parliamentary control would be defeated and it would be possible for central government to present a fait accompli to the 2 houses of Parliament, and neither house would be able to remedy the mischief done even if it disapproved the proclamation. Moreover, either House of Parliament may disapprove the proclamation even before the expiry of 2 months, and where that happens, the President would be bound to revoke the proclamation immediately because the proclamation cannot continue in defiance of the will of either House of Parliament without destroying the collective responsibility of Council of Ministers to the House. It was also, this is the contention, it was also urged that during the period of 2 months, no power can be exercised in virtue of the proclamation, which would bring about a final and irrevocable consequence if the President has reason to believe that either House of Parliament may not approve it, or also the control of the House of Parliament would be completely set at naught, and executive would be able to take irreversible action like dissolution of assembly by passing both houses of Parliament and ignoring their wishes.
In Rajasthan, state of Rajasthan, somewhat affected by the subsequent decision in Bomai?
Yes,
because Rajasthan was 77. That was when Mr. Charan Singh wrote the letter to the...
No, it comes subsequent.
And I thought that Rajasthan is substantially diluted by Bomai.
It is, my lord. That's what, that part I am going to read.
Yes.
Therefore, I have put it, my lord, chronologically so that your lordship gets everything at one, in one document without shuffling.
This is not the majority dissent. This is Justice Bhagwati's decision, not the majority.
In Rajasthan.
Majority, I can show, this is a better worded from my point of view. Majority says the same thing. I'll show, my lord, those paragraphs tomorrow. So let's not, my lord, give off the cuff, my lord, answer. 160, I'm sorry, my lord. Let me not give off the, I'll put it, my lord, that way. It would be clear from this discussion that when a proclamation is validly issued by the President, same judgment, no? Para 146.
All right.
I'll not give, I'm not reading, but I'll give the majority also, saying the same thing. But wording wise, I found this to be matching my submissions more. It would be clear from this discussion that when a proclamation is validly issued by the President under Article 356, Clause 1, it has immediate force and effect the moment it is issued, and where by proclamation the President has assumed to himself the powers of the governor under subclause A, he is entitled to exercise those powers as fully and effectively as the governor during the period of 2 months when the proclamation is in operation. There is no limitation imposed by any article of the Constitution that these powers of the governor can be exercised by the President only when they have no irreversible consequences, and where they have such consequence, they cannot be exercised until the proclamation is approved by both houses of Parliament. Here in this case, I must add, they are approved also when the decision was taken by both the houses on all occasions. Whilst the proclamation is in force during the period of 2 months, The President can exercise all the powers of the governor assumed by him, and the court cannot read any limitation which would have the effect of cutting down the width and amplitude of such powers by confining their exercise only to those cases where no irretrievable consequences would ensue, which would be beyond repair. When any power of the governor is assumed by the President under the proclamation, the President can, during the 2 months when the proclamation is in force, do whatever the governor could in exercise of such power, and it would be immaterial whether the consequence of the exercise of such power is final and irrevocable or not. To hold otherwise would be to refuse to give full effect to the proclamation which, as pointed out above, continues to operate with full force and vigor during the period of 2 months. It would be rewriting Article 356 and making approval of both houses of parliament a condition precedent to the coming into force of the proclamation so far as the particular power is concerned. Now kindly see, my lord, only the bold part. It is true that once the legislative assembly of the state is dissolved by the president in exercise of the power assumed by him under the proclamation, it would be impossible to restore the status quo ante if the proclamation is not approved by both houses of parliament. But that is the inevitable consequence flowing from the exercise of the power which the president undoubtedly possesses during the time that the proclamation is in force. Then again, my lord, only the bold part. It is therefore not possible to exceed. But the rest I am not skipping because it's against me. I am skipping because I'm in a hurry. That kindly take it away. If your lordship would like me to read, I can read everything. It is therefore not possible to accede to the argument of the petitioner in the writ petitions that during the period of 2 months before approval of the proclamation by the two houses of parliament, no irreversible action such as dissolution of the assembly of the state can be taken. The power to dissolve the legislative assembly of the state cannot also be denied to the president on the ground that the proclamation may not be approved by one or other house. In the first place, the existence of a constitutional power or the validity of its exercise cannot be determined by reference to a possible contingency. The court cannot enter into the realm of conjecture and surmises and speculate as to what would be the position at the expiration of 2 months, whether the proclamation will be approved by both houses of parliament or not. Secondly, it is entirely immaterial whether or not the proclamation is approved by both houses of parliament, because even if it is not so approved, it would continue to be in force and effect for a full period of 2 months. Lord, this is diluted in Bomai, SR Bomai. My lord, please come to page 150, next page, my lord. Justice Sawant and Justice Kuldeep Singh's judgment. (153), my lord, are the summary of conclusions. On this point, it is conclusion number 4, Roman 4. Since the provisions contained in clause 3 of article, am I with your lordship, my lord? On my lord Justice call, my lord, page 150. Since the provisions contained in clause 3 of article 356 are intended to be a check on power of the president under clause 1 thereof, it will not be permissible for the president to exercise powers under subclause A, B, and C of the latter clause to take irreversible actions till, please mark this, my lord. This is the only dilution and this is the only limitation. Till at least both the houses of parliament have approved of the proclamation. And this is definitely the majority. So, Lord, here, when the actions which are impugned were taken, they passed the muster thrice. The proclamation passed the muster thrice. Then, my lord, then Justice Pandian, I find myself in agreement with the opinion of Justice Sawant on his conclusion 1, 2, and 4 to 8, with which Justice B.P. Jeevan Reddy concurs in his judgment. So this becomes, my lord, a majority view. And last, my lord, Justice Jeevan Reddy and Justice Agarwal, in light of the reasons given and conclusions recorded herein above, we find ourselves in agreement with conclusions 1, 2, and 4 to 7 in the judgment of our learned brother Sawant, Justice Sawant, delivered on behalf of himself and Justice Kuldeep Singh. We are also in broad agreement with conclusion number 8. My lord, then Badrinath is the last judgment, my lord, I'll read. Only the first part, para 25. When an elected, my lord, your lordships have that?
Yes.
My lord Justice Gavai, yes. Page 150. When an elected government is not in office, the orders of the governor under Article 356(1)(a) as an agent of the President of India are equivalent to the orders that might have been passed by an elected government in office, and the governor's orders had to be given effect fully and could not be ignored either by the executive or by UPSC, etc. etc. Then, my lord, kindly come to, my lord, one paragraph of in S.R. Bomai at page 152. Justice Jeevan Reddy's my lord, exposition on this at page 153. I am not reading the rest, my lord. Your lordships may, my lord, it gives, my lord, what happens when 356 is implemented. Then at 153, fourth line from the top. My lord Justice Surikant and Justice Gavai has taken page. I am on page 153, fourth line from the top. Coming to subclause B, your lordship gets that number?
Yes.
Coming to subclause B, when it speaks of the powers of legislature of the state being made exercisable by parliament or under its authority, it cannot and does not mean or imply dissolution of the legislature of the state. It is significant to note that the subclause refers to legislature of the state and not legislative assembly. In a given state, the legislature may consist of legislative assembly as well as legislative council. In such a case, there can be no question of dissolving the legislative council since it is continuing body. Only the legislative assembly can be dissolved. In other words, there can be no question of dissolution of legislature of the state, the expression employed in clause B. The question may then arise, why was subclause B put in and what does it imply? Because entire legislation is not being dissolved, only assembly is being dissolved. And the court answers. The answer must be that when the government of the state is dismissed or removed from house, the legislative assembly cannot function normally. It is difficult to visualize a legislative assembly or for that matter legislature functioning without a council of ministers, i.e. government. Thus, where the government of a state is dismissed or removed from office, or here resignation, the legislature of the state becomes ipso facto unworkable. It is for this reason that subclause B provides that powers of the legislature of the state shall be exercisable by or under the authority of parliament. The best exposition, my lord, of sub-article B. So, my lord, these are my respectful submissions, my lord. Lord, I am immensely grateful, very patient hearing, my lord, and it's always a learning experience, my lord, before your lord.
Thank you, Mr. Solicitor. Thank you.
Lord, I wanted to read, my lord, the concluding speech of Dr. Ambedkar, my lord, at the conclusion of the assembly,
22 November
Constituent
1940.
Assembly. But if time permits, at the end, my lord, I'll read for 5-7 minutes. It's a beautiful speech, my lord, at the end of the parliament. And not right now, my lord, coming in the way of me.
Habits was very hard since while I was trying to read late at night through my iPad, still scribbling on the paper and then making some notes. So it's more than 61 years ago, we had If you lordships recollect, I had given my 2 sets of written submission. Where is that at volume? Detailed written submissions, which is at volume 4. I don't propose to read at length but some essential aspects which I thought can supply by way of an addition to the arguments made before your lordships.
Which volume are you
Before I
referring?
do that, this is volume 4. PDF, it's a page, it's a separate written submission on behalf of the Attorney General for India.
That's volume 4.
That's right. And then I handed over a 2-page note on the last occasion with a summary of my submissions.
Your opening arguments.
Yes, yes. Which company? It's 61 years ago, we had Puran Lal Lakhanpal wanting to
Whether he has any health problem.
Oh my God.
Not a very good compliment for me, man.
kept others alive.
Brother Gavi got worried, because he noticed that the same position persisted for 30 minutes.
Fortunately, he was the only one. Fortunately for me, he was the only one.
Fortunately, he is.
Very good. Yeah, please. In continuation of my summary, your lordships have been taken through the whole historical narrations. And in matters like this, it's very difficult to capture their entire history. Through a list of dates narration, we want to communicate to the court what exactly happened for a period of 5 momentous years before 1950. And they convey only a very telescope point of view. And a large amount of literature which is available to all of us to say how this momentous process took shape. Through a variety of efforts and engagements and ideas and conglomeration of thoughts. But by and large, the history has been brought before your lordships. But for the narration of history, the understanding of not only Article 370, but with the constitutional integration process would have been incomplete. And that's where the detailed list of dates narration with the learned solicitor occupies an important space. Now, they said 61 years ago, Puran Lal Lakhanpal wanted to contest an election. Now, his dream has come true. He can contest an election in Jammu Kashmir. He had to wait for 61 years for all of us. All of us are Puran Lal and Lakhanpal, in a way. So this is a grand contribution to what one may say, but it's a very significant historical constitutional process that has taken place in the history of India. Now, why do we have to look at the historical narrative? that, of course, both sides would like to place a certain perspective on why a certain course of events alone are important. If you look at the constitutional integration process of the rest of the country and compare it to the constitutional integration of J&K, the historical narrative shows that there is no fundamental distinction at all. Is the political compulsions which happened in the context of J&K made a very slight deviation. And that deviation is, again, I would call a formalization of the principles and the procedures for integration. Article 370 is nothing but the outcome of the formalization of the principles and the procedures for integration. Well, the rest of the country had gone through all that process. Union of states, merger of small territories, and the idea of a constitutional assembly and framing a constitution of their own, all that process have gone through. But since there was little intervention, which is a political historical fact, Article 370 had to intervene. And if you try to attribute to Article 370 any other purpose or intent, then I think we're fundamentally mistaken. So we are asked to go back, I would probably ask you a lot to go back to 1949, 1950, and look at from the point of those who are engaged in framing Article 370, and with the visualization as to what would happen soon thereafter to the integration process of Article 370. Instead of that, we are sitting today, almost 60, 70 years later, and trying to imagine into Article 370 what contemporary context want us to imagine. I say that imagination to a large extent is forbidden. So we have to look at it from the text and context and the intent and content of Article 370. Let me quickly formulate my understanding of Article 370. I don't propose to read in extent so many of the judgments which have looked into Article 370. If you'll also kindly turn to my written submissions. Beginning. Page PDF, internal page 27 of my written submissions. And please turn before that to page 30, paragraph 9.
30.
The three dimensions of Article 370. A, you'll also have that page. A, enabling Parliament to legislate in respect of matters in para 1 and 2 of subclauses B of clause 1 of Article 370. B, application of the provisions of the Constitution of India, subject to exceptions and modifications in the clause C of clause 1 of Article 370. And C, termination of the role of Article 370 under clause C of Article 370. These are the three dimensions. Then the requirements of consultation, concurrence, and recommendation, as the case may be, are the processes to be followed by the President. And I think for the purpose of our understanding, it's unnecessary to go into the question of concurrence and consultation, etc., and the distinctions. But since we are debating on the proviso to clause 3 of Article 370 and the recommendation clause, we need to place some attention to that. In my understanding, if you not kindly see the exceptions, modifications, additions, changes, power is, I think, virtually available in the entire spectrum of the Constitution of India in different contexts and for different purposes. But more prominently, when you come to the 5th and the 6th schedule, the legislation-making power of the governor has been noticed by this court on more than one occasion, and I'll place only one recent judgment. Kindly turn to paragraph 10. At page 30, this is the Constitution-made judgment on the powers of the governor under the 5th schedule, paragraph 39 and page 30, it begins at page 30. Your lordships may skip forward to the next page and turn over to page 32. Middle of that page, page 32. There's a sentence beginning, the extent of the legislative power of the governor. The extent of the legislative power of the governor under section 92 of the Government of India Act 1935 in making a regulation for the peace and good government of any area conferred on the governor in the words of Lord Halsbury, an utmost discretion of enactment for the attainment of objects pointed to. In that case, the words which fell for consideration judicial committee for the power of Parliament of Canada to make provisions for the administration, peace, order and good governance for any territory, not for the time being included in any province. It contended that if any legislation differed from the provisions in England had been made for the administration of peace, order and good governance, the same could not be sustained as valid. That contention was not accepted. Then kindly turn over to the next page, page 33. This sentence beginning, applying the law, the middle of the paragraph. Applying law to an area is making regulations which are laws. So the power to apply laws is inherent when there is the power to repeal or amend any act or any existing law applicable to the area in question. The power to apply laws is really to bring into legal effect sections of an act as if the same act had been enacted in the entirety. Application of laws is one of the recognized forms of legislation. You'll also find in Article 370, the application principle is virtually distributed in Article 370. I just presently read that. So the application principle of laws were recognized forms of legislation. Therefore, I would probably say that Article 370 conferring power on the president is not in the nature of an executive power of the president. The executive head is conferred a legislative power, a very extensive and wide power. The power to modify a parliamentary law, the power to subject a constitution to modification is a very vast power. And that's conferred on the president not as an executive head. And therefore, in order the president is enabled in exercising that power, we have only those processes to be followed. Concurrence and consultation. So if the scheme was to have a provision to facilitate and aid the constitutional integration processes, we need all that to put in place. The comfort and the aspirations also to be not to be compromised, and therefore you have a concurrence and the consultation.
Mr. Tony, if we accept that position, is something which we put to the other side. What has been the practice and the convention is something different.
No, that practice in fact flows from what the president was expected to do in order to complete the process of integration, the constitutional integration process. It is not linearly, unilaterally flow from the deliberations of the Constituent Assembly of J&K.
Oh, we understand.
It was not a sole authority, yes.
We understand your argument to the extent that there were conflicting views expressed in the Constituent Assembly, which is quite you have pointed out, or what was pointed out. And what we have today is Article 370 as it stands in the Constitution. So we have to interpret that and apply that.
Yes. We don't kindly now turn to page 36, but we try to understand if this is a constitutional integration process. And the Constituent Assembly of J&K will play a role. Now, how do you really make that happen? So I said the two important elements of 370, namely extending the provisions of the Constitution on the one hand, and enabling Parliament to legislate in the meanwhile, as the Assembly is in the process of drafting a constitution for the state of J&K. Very essential, important steps of Parliament in the meanwhile will legislate for the state of J&K. And the extension of provisions of the Constitution are equally important. They're the two limbs, important limbs. These are two important limbs in the hands of the President, and a terminus point will have to arrive at some point of time. I try to imagine that if Article 370 did not have clause 3 at all, it's impossible to think of a provision like this without a terminus point. But it is not to serve a perpetual aid and advice position for the state of J&K through extending periodically, or what has happened over a period of time is, what the President has done is by updating various provisions of the Constitution by issuing various constitutional orders. The updating exercise went on till recently. Beyond the CO 54 in 1965, by which time the majority and important provisions of the Constitution were extended to the state of J&K. Beyond that, except on two occasions, it became contentious. They are really updating exercises. So if Article 370 was to be conceived as a permanent updating exercise, one would have wondered why it should have come at the time of enactment of the Constitution or constitutional integration with J&K. It could take an entirely different shape. So that was certainly not the intention. So if a terminus point has brought in, and that power has to be necessarily vested in the President. Now Article 370 begins with a non-obstante clause. I understand, notwithstanding anything in this Constitution, also house Article 368. Anything done within the scheme of Article 370, anything and everything done by the President, doesn't admit of any role for Article 368. So therefore, when Article 368 does not come into the scheme of the Constitution, the argument that during a President's rule in 356, you could not have probably taken any measures reversible or irreversible without treading the path of Article 368 in this conceit. So if the realistic understanding of Article 370 was to complete a scheme, let's say at one level, enactment of the Constitution of J&K to the deliberation of the Legislative Constituent Assembly, and it must come to an end at that point of time. And if it came to an end by that point of time, because Sections 3 and 5 virtually captured the essence of constitutional integration, and nothing more required to be done after Section 3 and 5 becoming the part of the constitutional document. It hardly matters whether you call it today the Constitution, we not get into the question at all. Therefore, if the integration process contemplated came to an end by enactment of Section 3 and 5 of the Constitution of J&K, that's at one level. At a different level, if thereafter President has issued various orders in exercise of powers under Article 371D, and if I am right in saying they're all essentially updating orders, except those two controversial orders, where Article 35A came, I ask myself a question: is the President precluded from taking stock of all that has happened under Article 371D and say, what shall I do with it today? That today can come at any point of time. There is nothing, therefore, in the scheme of Article 370 enabling or injuncting the President to ask this question. She is entitled to ask this question at any point of time At any given point of time, if there's a trigger which facilitates and enables the president to take stock of the whole situation. So COs 272, 273, which are preceded by stock taking authority of the president. The president has taken stock, or whether what shall I do with Article 370? Should it continue, or should it be called to have served its purpose and terminate it? If that authority of the president is untrammeled, the measures taken by the president to deal with looking for aid and assistance measures in terminating it, coupled with what the parliament ultimately did in dealing with a very vast question of bringing peace and restoration to the state of J&K. So we are trying to tell you, Lordship, that justiciability probably will not come in. Now, let me try to understand why the J&K, the Constituent Assembly was given only a narrow power of recommendation. Well, yes, it was necessary to have the recommendation taken from the Constituent Assembly, but that necessity does not enlarge the scope of the role given to the Assembly, which is a very narrow role, namely a recommendation role. One would probably be able to argue that if the Assembly, having dissolved itself, the proviso probably would have expired on its own. It's no longer operating. If it's no longer operative and cannot be operated at all, then can you say as the tail cannot wag the dog, etc., although it is figurative, metaphorical. But what I mean to say is this: the president lose the authority and power available in Article 370, Clause 3, to bring to a close the entire scheme of Article 370. I would say the president has not lost that power. In the presidential poll case, question was whether, by reason of the fact that the Gujarat Assembly was dissolved, I presently played that citation. Gujarat Assembly was dissolved, and for the conduct of the election to the president, the electoral college is incomplete. And the election will be complete in a certain period. That's a mandate of the Constitution. But you can't do it now. Your Lordship in a 140 reference says, if the mandate of holding an election within a period now becomes impossible without an electoral college being available there, does not relieve the mandate from being complied with. So therefore, in certain circumstances, certain what called facilitating or what is called the recommending role of the Assembly is just not available. The President's authority under Article 373 can operate without any further assistance from any other authority. The President could have said under Article 371D, which is precisely what has happened here. He did not require any further assistance from any other authority. But by way of abundant caution, in continuation of what happened earlier under Article 371D, the President follows the same footsteps now, substituting Legislative Assembly in the place of the Constituent Assembly. So whatever gap, a suggested gap may be perceived, President says, now I'll fill that gap. There are several situations when such conditions, preconditions of performance cannot be performed. It's called the doctrine of impossibility. So therefore, the performance is not relaxed, relieved. Performance will still be done. The conditions may be ignored. So therefore, if following an earlier precedent of Article 371D invocation, we had the substitution of Legislative Assembly in the place of Constituent Assembly, the President follows suit. Please also bear in mind when the role,
see, when it referred to subclause D to Article 371, to the government of the state. Now, if one has to take the concurrence of the government of the state, read clause 3 of Article 370 as giving complete and absolute power to the president will be virtually going against the entire object and purpose of the enactment, because otherwise clause D and the proviso says concurrent state governments becomes a formality. When we read that article, when we read clause 3 to Article 370, we cannot ignore the Article 370, clause 1, including D and the proviso, state government.
That's right. Right.
Not to the Sadr Riyasat, but Council of Ministers. Governor with the Council of Ministers.
Let me try to look at it from that side.
So if you're going to read clause 3 of Article 370 in isolation without reference to subclause D to Article 371, and then argue that this absolute power given, or absolute because there's an integration which has to be done, will it not be in conflict with, or not be in terms of the entire purport of the article itself?
The perceptions about this conflict arise because we are dealing with a provision which was meant to work during a certain period. And during the period, how it should have worked. And since it crossed that period, we have all these questions which are apparently in conflict. So therefore, if you go back to a period prior to 1957, and imagine what would have happened if the Constituent Assembly had recommended to the President to dissolve or to delete Article 370, partially or fully. Question would have been entirely different. So because it did not happen, we have to put in position a certain understanding as to make it, give it a meaning and context till ultimately President takes stock on that. So that giving a meaning and context and relevance will flow from what has happened over a period of time. And what the President can ultimately do in our understanding of the role and relevance of Article 370. And that's the most fundamental thing. Is the role and relevance of Article 370, regardless of its exercise over a period of time, is clearly understood by the President now. Then by what other normative yardstick about the relevance of Article 370 will the court judicially scrutinize the exercise of power by the President today?
Yeah, even if but in this case, is there any President's proclamation excising power under clause 3 to Article 370? Saying that I'm abrogating Article 370?
I'll just come back. Can I come back to it by after reading of some part of in the line of my presentation? Kindly come to, let me complete this and come to your Lordship to answer your Lordship's question. Page 36 of my written submission, we're talking about paragraph 12. We're talking about the recommendation role. I would just want to finish that part of the argument and then try to come back to this. Kindly turn to page 36, paragraph 12. Because if we try to extol the recommendation role beyond a certain level, then we are rewriting Article 370. So the recommendation role is a very minimal role. And how is it being understood in different contexts? We have
does a recommendation postulate a positive recommendation, or does it mean just any
it is
opinion?
an advice. It is an advice. So it's an advice to facilitate and enable the president to find as to whether Article 370 has served its purpose and to close it. So the whole clause 3 of Article 370 is to render Article 370 inoperative.
But what
in that context.
Suppose there is a constituent assembly.
Yes.
We'll not go into this issue of the constituent assembly and the legislative assembly. And the constituent assembly recommends to the president, do not abrogate Article 370. Is it open to the president then to override the advice?
That power of recommendation is not available to the constituent assembly.
Sorry?
The assembly has to only recommend the president in regard to rendering Article 370 inoperative. The president seeks that advice from the assembly. The assembly will not say, I have my different thinking on Article 350 and I'll ask you to retain 370 the way we want it. So therefore, the advice, the recommendation
is not just an opinion.
Yeah.
When the Constitution uses the expression recommendation, it means a positive decision, because Article 370 uses different phrases. It uses consultation, it uses concurrence, it uses decision, and it uses recommendation.
Certainly right. So therefore, the use in Article 370 of all these distinct expressions, concurrence, consultation, have their context. So therefore, recommendation is seen as an entirely distinct idea altogether. If the Constituent Assembly was to...
contending that even if the Constituent Assembly were to say that please don't abrogate 370, the President can still abrogate 370?
She can. She can. Recommendation is not binding on the President. Therefore, it is recommendation. It is not concurrence. So concurrence for the purpose of concurrence for the purpose where you get the provisions of the Constitution extended stands in a different thing altogether. Consultation where the Parliament will enable to enact during that period. Consultation. So recommendation occupies that it comes at the end of the day when all the parties have understood that the job of 370 is done. What shall I do? The President says, let me know what I shall do now. I want to probably say, I have taken stock of all the presidential orders issued. The constitutional integration process is over. Now, is there anything left by way of invoking Article 370 or extending the provisions of the Constitution of India to J&K? That question will have to be necessarily asked. When that question is asked, what is the role of the Constituent Assembly? So if the 370 had envisaged a larger role, that would have defeated the very purpose of constitutional integration. Therefore, the only relevant...
Mr. Attorney, the use of the expression recommendation is not by itself dispositive of the content of the expression as to whether it is merely an advice, whether it is a condition precedent. I'll give you two examples. See, there are two examples in the Constitution where the word recommendation is used. Article 109 and 117. Yes. Article 109 deals with money bills. A money bill, after it is passed by is not introduced in the Rajya Sabha. Always introduced in the Lok Sabha. After the bill is passed by the Rajya Sabha, by the Lok Sabha, it is transmitted to the Lok Sabha, to the Rajya Sabha for its recommendations. Those recommendations are not binding on the Lok Sabha. It may either accept them, it may accept them in part, it may reject them. That is what Article 109 says. So in Article 109(2), see the way it is worded. The recommendation of the Rajya Sabha doesn't bind the Lok Sabha on a money bill. Now see 117. 117 says that a money bill cannot be introduced except on the recommendation of the President. 117. A bill or amendment making provision for any of the matters specified in subclauses A to F of clause 1 of Article 110, I'll go to 110 in a moment, shall not be introduced or moved except on the recommendation of the President. Now, in Article 117, the same word is used, recommendation. Recommendation is mandatory. You can't move a money bill unless there is a recommendation by the President. Now comes 370. There are many other provisions of the Constitution. I think, if I'm not mistaken, in my dissent in Aadhaar, I had analyzed those provisions of recommendation. Now see 370. It says, provided that the recommendation of the Constituent Assembly of the state
Shall be necessary.
shall be necessary before.
That's right.
Shall be necessary and before. So it's a condition precedent and a condition in terms of time. It can't be a post facto recommendation. It has to be before. What is the reason for it? There has to be a recommendation by the Constituent Assembly for the abrogation of Article 370. And second, that recommendation has to be before the President decides to abrogate it. Therefore, to say that, this recommendation is just an opinion, it's not binding on the President.
My submission is not to slight that recommendation role, but I say it's still only a recommendation. Let me try to explain. The necessity of having a recommendation does not add any further content to the role of recommendation. There is a procedure which is required because during the constitution integration process.
So your contention is that you have to have a recommendation.
Yes.
And it's not binding. It may be a positive or negative recommendation. The President can override whatever is said by the Constituent Assembly.
No, the reason why, therefore, what I would call a minimal role of recommendation given to the Constituent Assembly is in the context of one, the scheme of Article 370, and that being part of the larger integration process, can a body like the Constituent Assembly of J&K can have a final say on Article 370? It is not a constituent body of a Parliament of India. It doesn't have all that attributes and powers. So the recommendatory role has been assigned in the context, keeping in mind that once the constitutional integration process is completed, in the understanding of all the parties involved, there has to be a terminus. And to bring that terminus to a completion, then the role of recommendation is assigned. Otherwise, the Constituent Assembly could have been probably given the powers of consultation, concurrence. Why is state government coming into Article 370 at all? So it's only at the end of the day when you have done all that job. It's a stock-taking exercise. And it will probably envisage that you will do it before the constitutional integration process gets over.
What is the sequitur? Are you therefore contending that therefore, since this was purely recommendatory, therefore the absence of a recommendation also doesn't make a difference? Is that the submission or what is the submission?
I'll personally try to address the question. That's only when...
Hundred and 3.2, yes.
There are different...
Qualifications. Wherever they want that the opinion or recommendation should be acted upon, they say so. It will be referred to the commission will give an opinion, and then it says, and shall act according to such opinion, which is missing in
act according to...
Just my note, I have mentioned, I didn't read it, but the President of India being bound solely by a body which is outside the Constitution of India, Lord, may perhaps not be the correct interpretation of our Constitution. That if it says yes, he can do it. If he says no, President cannot do it. Because Constitution of Jammu and Kashmir is beyond and outside our Constitution.
Clause D does the same thing. It says that other provisions of the Constitution can be adopted subject to such modifications and exceptions. If they relate to the instrument of accession, consultation. Anything else, concurrence.
Of the state government.
Of this
Not Constituent Assembly.
Not to the assembly.
No, but then if the Constituent Assembly was not in existence, then it has to be placed before the Constituent Assembly for its decision. That means even in the case of the operation of clause D, read with subsection with clause 2, the Constituent Assembly is given the overriding power, even in relation to the President.
Till it survives, till it.
This slight difference. See, you can't say when Article 370 itself refers to Constituent Assembly, you can't say that this Constituent Assembly is outside the Constitution. It's within the constitutional framework because it refers to it. Yes, your argument that once the Constituent Assembly is no longer there, what will be the position with regard to Clause 3 to 370 is something which we'll have to examine. With reference to the procedure you have, with reference to, because the judgments itself, many of the constitutional bench judgments itself says we are not examining that issue. We'll have to examine.
Only worry is, only with permission of the learned AG, the worry is, suppose this exercise would have been undertaken in 2007, in 57, when Constituent Assembly was in existence. Suppose it would have recommended that don't abolish or don't abrogate or apply with modification that none of the provisions of the Constitution of India would be applicable or never apply fundamental rights with that modification. Lord, I'm putting a question to myself, the President of India will denuded of its powers? Lord? Was it intended that by not recommending not to abrogate, it would become permanent?
We have taken that argument.
Put it in other words.
That proviso will no longer be applicable after the Constituent Assembly is not there, but that will not deprive the President of his power under Clause 3.
To put it in other words, if the object and the role of Article 370 is essentially and fundamentally a constitutional integration process, anything which emanates from the Assembly, to the contrary, as a way of negation of the integration process, would be forbidden under the scheme of Article 370. You can't have a negation there.
Mr. Tony, you extended that argument, therefore the questions arose. You extended the argument to say recommendation only means advice and even no advice. Suppose the Constituent Assembly was, that's assuming that the Constituent Assembly was
Therefore,
there.
I quite see.
That part, the extension part is the one which is.
We have to probably understand the context in which why this provision was at all enacted. The Constitution integration process repeated was the only mantra under Article 370. And everything around it revolves around it. 371, A, B, the Parliament is enabled to legislate, extension of provisions of the Constitution, they all revolve around this central theme.
See, the only thing is in relation to Jammu and Kashmir, one thing is very clear from reading Article 370. It expressly recognizes the instrument of accession. Categorical recognition of the instrument of accession in Article 370 itself. Second, a categorical recognition in Article 370 of the process of the formation of the Constitution of the state of Jammu and Kashmir. Third, a categorical recognition of the status of the Constituent Assembly of Jammu and Kashmir. So therefore, it's not that these were instances which were taking place as a part of the real politic in that state. The IOA, the Constituent Assembly, the process of constitution formation in Jammu and Kashmir, they are expressly recognized in Article 370.
That's right. My
So they have been conferred with a certain constitutional recognition, if not a constitutional status. a constitutional recognition in Article 370.
I just want to enter a small caveat because the historical narrative about what happened in the rest of the country towards constitutional integration. As I said, essentially the process was one and the same. Constituent assemblies.
You are right,
formation
Mr.
of
Attorney
states.
General. You are right, Mr. Attorney General, to the point that this was in aid of constitutional integration.
Yes,
And as we see that integration was taking place by and by
yes.
from 1957 right through to 2019. So subjects which were completely excluded to the Parliament were brought in within the purview of Parliament. That was also a clear understanding of the constitutional movement towards greater integration of Jammu and Kashmir into the Republic of India and the Dominion of India originally, and the Republic of India. So there was undoubtedly a gradual and imperceptible integration apart from the unconditional accession to India, which we saw right at the outset in Article 3. There's no difficulty about that. But the only point really is this, that there are two ways of looking at Article 373. If the proviso can't apply, we keep 367 apart for a moment. If the proviso to Article 373 cannot apply, does that mean that the power under the substantive part of 370 is completely denuded or lost?
No. The answer will be no. I'll try to.
That's the
power is not lost.
And if that power is not lost, is it a unilateral power then which can be exercised by the president? What Parliament really did was this. They didn't have a constituent assembly in the state of Jammu and Kashmir. There was no constituent assembly. They were exercising this power to abrogate. They followed the 367 course, obviously, with an idea that in the absence of a constituent assembly, there's no legislative assembly in the state. You go to Parliament, which in that sense represents the broad diversity of
democratize the decision.
You have the Rajya Sabha, which is the Council of States,
Correct.
which represents the overall diversity of the nation. You have the Lok Sabha, which consists of elected representatives of the nation. But in that process, there's one, I wouldn't say casualty, but one dilution. And that dilution is the role which was ascribed by the proviso to Article 370(3). Now, that role can, as you are trying to sort of elaborate, that role is merely recommendatory. Merely because that role is recommendatory does not mean that it can be dispensed with, because the Constitution provides for a recommendation. When a Constitution provides for recommendation, we can't say that, well, even if there's no recommendation, that's fine, you can override it.
My endeavor
Can
is.
I just add one thing? Sorry.
Sorry.
Sorry to interrupt. You see, after you amend 367, you say legislative assembly is equal to constituent assembly. We have to take it to the logical conclusion.
We've accepted that it exists, but
That's right. That's how it has.
But my lord, only one question, my lord, and your lordships can consider this, my lord, during this holiday. My lord, suppose in 1957, at the time when the Constitution was framed, Constitution of Jammu and Kashmir.
Yes.
And the Constituent Assembly was dissolving itself. Last speeches were made, etc. Suppose it would have said that now in exercise of our powers under 370, sub-article 3, we recommend the President that the Constitution which we have framed will provide for a semi kind of monarchy, and now therefore you delete 370. Lord, would it not go against the very spirit with which 370 was incorporated? That it has to be temporary and you are an integral part, because 370 sub-article 3 says, notwithstanding anything contained in the foregoing provision, meaning thereby 1 and 2, instrument of accession and article 1 being applicable. So, Constituent Assembly technically was not bound by 1 and 2. It could have said, then my lord, would the President be completely denuded and act as per the desire of the Constituent Assembly? It cannot be, for the simple reason that the debates in the Constituent Assembly repeatedly say that this is a temporary provision.
So that's why I said you
You
can't.
don't have to refer to the debates.
So that's why,
Yeah, even the,
Until
that's
unless
why
you
I
ignore
said
it.
there can't be a negation principle read into the proviso. The principle of negation whittling down the entire scheme of Article 370. You can't read it into the proviso.
Let us say, bro, that as Sheikh Abdullah at that time wanted that independence resolution being passed. That's why you put in registered of the assembly.
It's the very that answer is given in the Article 370.
I'm saying, had they proposed, then the president is not bound.
No. That proposal is not, this will be contrary to Article 370.
That's right.
May I have your lordship's permission in support of this submission?
Contrary to Article 1 also.
Reading material can be shared with.
Kashmir is an integral part of it.
That's all right.
Question.
Some reading material can be shared with your lordships and then.
No, nothing in terms of reading material, Mr. Attorney.
We have enough reading material with us.
Now we will go by churning material, which they have at the bar.
I didn't want
Because then in rejoinder, we'll get a couple of thousand pages, Mr. Attorney, and we only know what difficulty that poses at the end to us.
Coming through that, I understand.
Give you a more accurate list of days.
These are some.
We put that discipline on you because we realized what could happen.
No, but what happened? That was. No.
So the facts which are on record in the word of Sardar Patel.
This is please let us not get into that. I don't think.
Please,
I don't-
Ms. Sybil,
I
you
don't-
will have your chance in the
I
second
don't
round.
think this statement is necessary at all. No, the reading material is some excerpts from certain books. Some thoughts come in the course of how do you explain internal sovereignty? How do you explain certain? I thought if they are useful, I can certainly.
One last word, then we'll rise, of course, then we'll think of all that you've argued for the holiday tomorrow. That the wide chasm between absolute autonomy as it existed on the 26th of January 1950, all right, and complete integration as it was brought about on 5th of August 2019, that chasm had been substantially bridged by what was happening in between. So really, in the sense, it was not a complete migration from absolute autonomy to absolute integration.
It had become a shell, my lord, as
Whether you call it a shell or not,
Gujarilal Nanda said.
it's obvious that a substantial degree of integration had already taken place in the last, between 1950 and 2009, 69 years.
The final
And therefore, what was done in 2019, was it really a logical step forward to achieve that integration?
Absolutely.
Actually, this integration was full already. The power in 1950, only assimilation was there.
Different meaning for us. The power to make those.
We have interesting issues, yes. We have interesting issues. Mr. Attorney, about how long would you take? About half an hour or so now?
More if possible.
Sorry?
Maybe an hour more.
After that, Mr. Dwivedi will.
Right.
we all know that it's the army which runs that country. As long as that continues, there's not much hope for any kind of rapprochement between India and Pakistan.
Imran, one of the many damages he did, you can say to the Pakistanis, he asked the right questions. Right now, where we are with Pakistan, they say for anything, you say normal common sense thing, they say no, first solve Kashmir.
China wants to integrate Pakistan into the BRICS alliance.
I don't think it's a serious thing, at least at this stage. In the list of 22 countries who've been already invited to come, Pakistan is not there.
Unfortunately, what Xi Jinping has done by re-centralizing economic decision making, he has sort of undone the Deng Xiaoping miracle, which was the Chinese miracle of 10% or more GDP growth per annum.
Main point about CPEC, Godar, is really how China has taken over the infrastructure development in Pakistan. And Pakistan does not have too many choices. I think one reason why the army took over, I think, de facto in Pakistan, is to get the economy fixed, go back to the IMF.
I don't think the West being relatively muted means that they do not oppose the destruction of churches and the harassment of people who are Christian.
Under Ayub Khan, Pakistan was a great friend of America, a great friend of China. Pakistan's weight was a global thing. That has dramatically diminished. So this is the tragedy of Pakistan. Except nuclear weapons, they have nothing.
There is no doubt that there's a very severe slowdown in the Chinese economy. It's not that I'm advising Xi Jinping on it, because if he's making mistakes, I will let him make those mistakes.
That's Chanakya Niti for you. Namaste, Jai Hind. Welcome to another edition of ANI Podcast with Smita Prakash. Today we discuss Pakistan and China and its ramifications on India. My guests today have tracked Pakistan and China for decades. Ambassador Gautam Bambawale has served as India's High Commissioner to Pakistan and India's Ambassador to China and India's Ambassador to Bhutan. He's also served as India's first Consul General in Guangzhou. C. Rajamohan is a senior fellow at the Asia Society Policy Institute, Delhi, a division of the Asia Society India Centre in Mumbai. Rajamohan has written extensively on Pakistan and China and foreign policy matters. His article, the title is Gulf Route to Pakistan. The article says that the United Arab Emirates has offered to invest in Pakistan to help the country out of its entrenched economic crisis, and that the UAE could emerge as an important economic bridge connecting the Indian subcontinent and the Gulf. On the podcast today are these two gentlemen to discuss this article and more. Thank you, Gautam, for finally coming down from Pune and coming to Delhi. Delhi all prettied up for you. You've noticed we've done up everything, right, Raja?
Yeah.
We've made this city so beautiful so that Gautam can come to Delhi and take part in the podcast.
I'm lucky I came a few days before the G20 summit.
No. We've done this just for you, Ambassador. But anyway, so we'll discuss your article, which we've been planning to talk on this article that you've written. Very interesting. But before that, let's talk about Pakistan. Both of you have written so much about Pakistan and about China, and you've followed the events there for a long time. So I just want to know about this current scenario. We're recording on the 24th, and I believe it's Imran Khan's thing is going to come up in Supreme Court, and there is talk that he might come out of jail again. So by the time we air this, you never know, he might be out. But I wanted to know about this President Arif Alvi, when he said that he refused to sign those bills. Somehow those bills get signed. Things are happening. What do you see? Why do you think it's happened? Gautam, you first.
Yeah, let me give you my inputs, or let me give you my viewpoint. I think this sort of epitomizes or gives us a very good idea of the state of Pakistan today. That the president of the country wants something to happen, but people down the line don't let that happen. It sums up the sort of mess that Pakistan is in today. Let me also say that, we all know that it's the army which runs that country. And in my view, in my opinion, as long as that continues, there's not much hope for any kind of rapprochement between India and Pakistan. And therefore, what we have seen in the last few months, where Imran Khan tried to take on the army but has not been able to do that, where there was popular anger against the army, which was seen in those attacks against,
people who are working in the army in Lahore and other places. That sort of shows that the people in Pakistan, the populace, is now beginning to see through the dong that the army is made of Pakistan. If that happens, and I had written an article on this which says that if we are able to push the Pak army back to the barracks, that means they take on the role of any normal army in any other country, then that would probably be a good thing, because then the politicians who are elected by the people of Pakistan could actually have a say in the nature of the relationship between India and Pakistan. So those are my broad views on what's been happening in Pakistan. Though, of course, economically, we all know it's in a mess. They have, of course, managed to get an IMF loan and money from other countries. And let's see how they move ahead on the economic front.
Raja, do you agree that in 70 years, we've never seen a time, even a brief period, where the army was willing to move back to the barracks and allow. And with this kind of a president who seems like very confused, whether he signed the bill or didn't sign the bill, or somebody in his staff signed the bill. So what has really happened? Do you think it's possible, even in the remote possibility, that the army is contemplating going back to the barracks?
Not at all. In fact, it's come out of the barracks. I think, to talk about the army in Pakistan, we always just say, most countries, the countries own the army, but in this case, the army owns the country. It looked like Imran Khan was breaking that paradigm with his popularity, though he himself was put in that place by the army. It looked like his popularity, he can challenge the army. And as we've seen, his ability to do so has been clipped quite severely. So just as we thought army has done this to other leaders before, to Zardari, to Nawaz Sharif, to Benazir, so they thought, okay, they put this guy away to cool his heels in the jail, and someday tell him, look, you want to go to London, you're free to go, but you're not going to do politics. But I think there are two jokers in the pack. One is Chief Justice of Pakistan, Bandial, who throughout the cases that have come has favored Imran Khan. But his term is coming to an end. So the question is, can the army control him when the cases come up in the next few days? Or they can arrest him again. Look, in South Asia, the police, you get out of on one charge, there are 100 other charges, because he just doesn't have one case. He has so many cases now put against him. And now the new issue of Official Secrets Act, that by going around with this piece of telegram that he got from, cipher telegram he got from Washington saying Americans were doing the conspiracy. So that law has also been amended. So Justice Bandial is a problem, the army has to fix him. The other joker in the pack is the president. The president was the nominee of Imran Khan at a time when Imran was working with the army. Now the problem for him has been, the army has come back, Imran is in jail, and the president, who's Imran's man, when he's not elected, he's nobody, actually Imran put him in that place. So the PTI, the Imran's party, people are saying, look, we put you there, what the hell are you doing for our leader? And are you saying you're signing these new laws which actually make sure that Imran will never get out? So I think he came under the pressure. So he's caught between the devil and the deep blue sea. He can't really confront the establishment. He can't pretend he owes nothing to Imran Khan. So I think he's doing the usual thing when we get caught in such a situation, fudging, doing a Bharatanatyam of, I signed it, but I didn't sign it. Somebody came and took the file away. I told him to say no. So I think he's saving his skin in a situation where it's very uncomfortable for him, that he can't really support Imran Khan fully. He can't defy the army. So he's trying to find the space. So I think if he and Bandial, the Chief Justice, act in tandem, they can create problems for the army. But I won't bet against the army in Pakistan. They've gone too far now. They've taken a lot of heat already. They brought in Imran, and I think Imran has made it very hard for them. So they're not going to let go of the situation. And so they have to fix these two guys. One guy will go out in 6 weeks, and this guy...
Fix it. That's what they do, right? Gautam, you've been High Commissioner in Islamabad. Tell me, I'm reading a few articles now, like truth bombs being dropped in some of the newspapers, some of the op-eds by Pakistani writers who say that, we've got left behind. Look where India is. Look where we are. We've been let down by the army. Bold enough to say that. not just the army, bold enough to say that we've been let down by our leaders. Nobody wants to look at us anymore on the international sphere. Did you see this when you were posted there? Did you see this kind of discrepancy between what people want, what people think, and what the rulers do?
No, that's an excellent question, Smita. When I was there, of course, it was the period when Nawaz was, the Panama Papers had just broken, and Nawaz was in a very uncomfortable position. And then eventually, as we know, and as Raja rightly said, the army made sure that he was out of office and he had to stay in London, etc., etc. But Imran Khan was already a rising force, and his party, the PTI, was a rising force at that point of time. One, of course, couldn't foresee that this kind of honeymoon between the PTI and Imran Khan on the one hand and the army on the other would be over so soon, in 3 years or so, not even a full term for Imran Khan. But I think what you're saying is absolutely right, that some cracks in this monolith, which used to be revered by the Pakistani people, which is the Pak military, the establishment, the Pakistan army basically, have begun to be seen. And increasingly, people are beginning to understand that the Pak army has not really done the country any great favors. It has kept the country together, and it has, done a wee bit in the defense of the nation. But in the longer term, it has not really done any great favors to Pakistan, and to a certain extent may even have held them back. So there was a slight indication of these kind of views at that time. But to be frank, not many people were willing or were brave enough to put it down in writing and say it in public, because they knew that Big Brother, which is the army, was always looking over their shoulder. And when I was there, we also had these 5 bloggers who dared to say such things, who disappeared overnight and were then missing for almost 2 to 5 weeks.
Disappeared is a term which is very strange. वो disappear हो गए, which means
disappeared हो गए in Pakistan means they're picked up by the ISI.
Yeah.
So picked up, and what they do
it's
with
used
them
very casually,
Yes.
I mean, the first time I heard it, Gautam, I was like, what do you mean disappear?
Yeah.
Like, it's like a word which was not something I was familiar with.
Let me tell you something, Smita and Raja, which will really, I used to play golf while in Islamabad, and you won't believe it, the guy who used to caddy for me also disappeared for 2-3 days.
Oh.
He reappeared after that, and I asked him, "Kya ho gaya tha?"
They
He
must
said
have
the
quizzed him
ISI
about you.
picked him up and asked me what I say to him on the golf course.
And he was a Pakistani, or
He was
a
a local Pakistani man.
Oh.
So, a caddy from the golf course whom I used to use regularly. So even he had been picked up by the ISI and quizzed and questioned about what I had spoken with him. And his answer, he said, I told him that he only talks to me about golf and nothing else.
If only the ISI would know that Gautam doesn't even talk to Indian journos. Caddy se kya baat karenge? But anyway, no, that's a joke apart. It's an inside joke that we used to have as journos when Gautam was, like High Commissioner. Bolte hi nahi the. We used to keep trying to get some information, but, till the Indian High Commissioner is not ready to speak, he would not. But then I guess that's like your job profile, right? But tell me something.
No, very often, Smita, and this is a joke also, people ask me, how the hell were you made ambassador to China and High Commissioner to Pakistan?
To Pakistan. Is that
so I told them, I have one qualification which you guys don't have, which is I speak very little.
But how many diplomats are there, Indian diplomats who've done both?
I think, according to our account, it's 3.
Okay, who are the others?
There was Mr. Shivshankar Menon and Mr. Vijay Nambiar.
There's one more. Vajpayee.
Vajpayee. Yeah. There's, of course, Mr. Shankar Vajpayee. So 4.
Have done China, Beijing
And,
as well as Islamabad.
Yeah.
And tell me something about it. Were you tailed by the ISI? I'll tell you my experience as a journalist. We used to have, when we went in to cover whatever event, and in fact, in one of them, you were managing the media and I was part of the delegation. Prime Minister Vajpayee, I think, if I'm not mistaken, or when he went for the one of the summits, I don't remember which one. But at that time, we used to have, people tailing us, and they would like say that, हाँ हम आपको वहाँ ले जाते हैं, यहाँ ले जाते हैं, and everybody knew. And it's the last day that you get to know that, okay, this guy was tailing you everywhere. But were you tailed?
All the time, and
all
it's very openly done.
Okay.
And I can tell you an anecdote. When you get old, you get into your anecdote age. So I seem to have fallen into that age category now. But I remember very clearly that we had driven to Lahore, and there was a particular address which our drivers just couldn't find. So the ISI car and the ISI man pulled up, and he said, "Arey yaar, for 10 minutes you have been going round and round. Just tell me where you want to go, and I'll take you
Escort
there."
it becomes an escort and not a tail.
So actually, the ISI came up and showed us where we had to go, which was we were missing one small lane or something of that
Time
sort.
barbad kar rahe ho.
But we was wasting
Your
his time.
pre-GPS era.
Time barbad kar rahe the. So he drove up and he said, "Tell me, and I'll take you where you want to go."
So, you've been ambassador in Beijing. So I will speak to you about this BRICS alliance and stuff. Before that, Raja, let me come to you. China wants to integrate Pakistan into the BRICS alliance. And India is, of course, opposing that. What is your view about this?
Look, I don't think it's a serious thing, at least at this stage. In the list of 22 countries who've been already invited to come, Pakistan is not there. I mean, it's we can believe that, look, China at some time would want to get them in, but India has a veto. So I don't think it's on the cards anytime soon that will actually happen. The debate really is about what about these 22 other countries who are friends of both, say, for example, Saudi Arabia, UAE, countries like that, who are all want to get in one form or the other. So that's where it is. Pakistan is still not in the front and center of the expansion debate. But I think what India is saying is, let's first work out the criteria. Again, that statement will come out today. At the end of the day today, 24th August, I think we'll get a sense of what they agreed, whether they're actually going to announce some names who are going to be taken in. And if they get taken in, I doubt if they'll become full members. It's like, are they observers? The two-tiered, three-tiered structure that like ASEAN has, most international organizations have. So all these are open at this point. So membership doesn't mean anything at this stage. You become an observer.
Do you think Pakistan is even trying?
No, I think
or they're too caught
no,
up
I think
with
they would love to get in.
they would love to, yes.
On the Chinese shoulders, but I don't think
it's not a serious thing right
at this point.
So the destruction of churches in Pakistan, even the UAE and other countries in West Asia have criticized Pakistan. The West seems to be muted in its response, and China completely silent. Do you think that this can become a big issue, or it'll just be one of the things that happens?
No, I think this has been a problem that has plagued Pakistan not just for the recent past, but for almost its entire existence. So it is a problem. I don't think the West being relatively muted means that they do not oppose the destruction of churches and the harassment of people who are Christian in their faith, etc. I don't think it means that they are not opposed to that. But it's something which has happened and in the past, and the West has made its opposition, its voice known on this subject. So I think they may have been muted this time because they are also distracted by their own problems at home. But I can't see them not being opposed to this particular thing.
I'll get to the CPEC issue, since you were posted both in China as well as in Islamabad. There were these suicide attacks which have happened, the Baloch Liberation Army. Before I begin this question, here's a primer. On August 13th, 2023, just a day before the Pakistan Independence Day, one group of the outlawed Baloch Liberation Army BLA attacked a convoy of Chinese engineers at the Gawadar port. This attack was similar to the attack in 2021 when a suicide attack was carried out on a convoy of Chinese engineers. A day later, a Baloch group issued an ultimatum to China to vacate its operations and people from Balochistan. In April 2022, a woman suicide attacker killed 3 Chinese teachers at Karachi University. The attack was aimed at the Chinese affiliates of the Confucius Institute. What is going to be the future of CPEC, the Chinese-Pakistan Economic Corridor, which incidentally India opposes? So the China-Pakistan Economic Corridor, the CPEC, Where does it stand? Do you think that China's rethinking on this billions of dollars, 6 billion or something like that?
No, the investment originally was supposed to be 60, then maybe 25, 30 already is coming.
Yeah, but now just the Pakistan sector is 6 billion, isn't it? Or more? 60.
No, much more.
That was the plan, but I think
But
it's maybe
it's
actual
become-
investments maybe in around 25,
Okay,
30.
25, 30 billion.
Yeah.
So what do you think? Is there a rethink? Will they just give up on Gwadar, or are they going to continue with it despite these attacks?
No, I don't think there's been a rethink, at least in Beijing. But the fact of the matter is that because of these 2.5 years of COVID, many of the projects under the Belt and Road Initiative, of which one part is the China-Pakistan Economic Corridor, have slowed down. And as a result of that, we'll have to see how they progress now that COVID is over more or less all over the world. The Pakistanis, of course, welcome this investment because there is no other investment coming into Pakistan. The only investment is what the Chinese government is putting in under CPEC, and Chinese companies coming in and doing all kinds of projects, including power projects and road projects, rail projects, etc. But eventually it also matters whether all these projects will be viable and whether they will turn profitable. And that is a big if, that's a big question mark, and we'll have to wait and see how that works out. Because, as you rightly said, there are huge domestic economic problems that Pakistan is grappling with. And even this investment, for it to be viable and profitable, would require, Pakistanis to make use of those projects. So let's see how it happens.
Raja, just break this down for me, for our viewers. The Belt Road Initiative, the CPEC part of it, and Balochistan. Where does this jigsaw puzzle, how do the pieces fall?
Look, I think the Belt and Road Initiative is exactly this. 10 years ago, that Xi Jinping announced that they're going to do this big infrastructure thing, both on the maritime side as well as overland. So that was called the Belt and Road Initiative. Now, what they did was, like in all, governments, after they created this big umbrella, they started shoving in the previous projects also underneath it. So the actual China-Pakistan Economic Corridor precedes the announcement of the Belt and Road. Over the years, in fact, Musharraf was still there. I think Hu Jintao went there to launch the port, construction. So I think this predates it, because if you remember, China was involved in Pakistan's at least 2-3 major projects. One was the Karakoram Highway that goes back to the 70s. That building, between Xinjiang and the, Pakistan-occupied Kashmir, that those connections, this goes back to the 70s when it was very hard to do engineering across the Karakorams. So in many ways, what you think of China-Pakistan Economic Corridor is really a modernization. Okay. One, you had to modernize the road across the Karakoram, and then you need a port, and then connect the two down the Indus River in various forms. So I think what they've tried to do is really to develop this. But there are two problems that came up. One, in fact, people like Imran were questioning this project. By the time he came to power, he said, look, the cost of interest is very high. So these are mostly loans. This is not that you have to pay back. So the interest cost, that was going up. So in fact, Imran, one of the many damages he did, you can say, to the Pakistanis, he asked the right questions. But the Chinese were very upset with him.
And that's why some commentators in India say that Imran is the best thing to happen to India, because he asked questions which damaged the Pakistan army.
Exactly.
Yeah.
So I think they kind of hushed it up, and Nawaz Sharif, the civilians were very big gung-ho on CPEC as well, like Nawaz Sharif and Zardari. The second, I think, what has seen Gwadar, attacks on Gwadar, was really the Baloch separatism that exists. So the Baloch have a historic complaint, even well before the Chinese came, that Punjabis exploit their resources, and they don't get any benefits. So there have been this long-standing central government agitations in Balochistan. It was crushed by Bhutto in the 70s, and now it's again the government keeps attacking them and does all kinds of things. And then what Pakistan did was army announced a separate army unit, right, a security unit to deal with the terrorist attacks and to protect the CPEC across the board. So I don't see the Chinese withdrawing from Gwadar. In fact, in India, we focus so much on Gwadar, but there is also the Karachi port, where the Chinese already are building ships. So the naval integration of China and Pakistan already takes place in Karachi, where that is headquarters of the Pakistan Navy. The Chinese Navy is building some ships for them. So the integration of the two navies, that is taking place. But overall, I mean, the main point about CPEC, Godar, is really how China has taken over the infrastructure development in Pakistan. And Pakistan does not have too many choices. And how do they manage it? That is the problem, because the costs of these projects is going up. And one uncertainty which Gautam can tell us a little more, the Chinese economy itself is slowing down. Now, it's not so clear how well the BRI as a whole, the investments plan will go.
If it's viable or not.
Yeah, over the longer term.
Yeah, could you tell me, do you think that will happen? One, whether it fits in, and two, is Pakistan okay being a client state of China? Because there's a lot of talk about that too in Pakistani press.
Let me answer the second question first about whether Pakistan is happy or satisfied or okay with being a client state. I think they don't have much of a choice because there's no one else who's investing in Pakistan. And when you have this big brother China coming and saying that we'll do the China-Pakistan economic corridor, billions of dollars, you accept it. So to a certain extent, they don't have a choice and therefore they've accepted it. Though people in Pakistan will always tell you that, we have nothing very common between the Chinese people and the Pakistani people. But I think where the nation states are concerned, their interests coincide. So it's they have to take it or then get into even worse kind of situation if they don't accept the kind of investments that China is putting in. As far as the first question is concerned, it's there's no doubt that there's a very severe slowdown in the Chinese economy. And as a result of that, the Chinese economy is facing huge problems. And we have been seeing more of the problems over the past few weeks. But I think we still need to watch the Chinese economy a little more over the next 6 months to see where exactly it is headed. There's no doubt that there is high levels of student unemployment, that is those students who are graduating, really large numbers of them are not getting jobs. You can see the real estate sector really crashing down, not only with Evergrande already announcing bankruptcy, but there's another big company which has thousands of projects across the country which is also in deep trouble, not repaid its loans to the banks, etc. So in the past, the Chinese used to overcome these problems by spending their way out of the problem. But today, with their domestic debt being very, very high, almost 300% of GDP, they're not even able to spend their way out of trouble and use it to produce and manufacture more infrastructure. So China seems to be in a little bit of a problem. In my opinion, the problem is as follows, but it's not that I'm advising Xi Jinping on it, because if he's making mistakes, I will let him make those mistakes. But
that's Chanakya Niti for you.
No, but I can share with all of you, with you, Smita, with you, Raja, and with your viewers and listeners, that I think the basic problem, in my view, which was made by Xi Jinping, is that the Chinese economic miracle created by Deng was done through a devolution of economic decision-making. Economic decision-making was let down and was allowed to be made by the smallest province, by the smallest, whatever it is, the principality, etc. Earlier in the Mao period, it was all centrally done in Beijing. So Beijing used to decide that some steel mill somewhere in a different part of China will produce so many tons of steel.
Which is communism for you.
Which is classic communism.
Yeah.
Now, Deng Xiaoping changed that by devolving economic decision-making powers. Unfortunately, what Xi Jinping has done is reversed that whole process. He has re-centralized not just political decision-making in his own hands, but also economic decision-making in the hands of the state-owned enterprises. In the action he has taken against the various private sector players in China, we have seen Jack Ma having to run away from China, etc., etc. And that's just the tip of the iceberg. So I think by re-centralizing economic decision-making, he has sort of undone the Deng Xiaoping miracle, which was the Chinese miracle of 10% or more GDP growth per annum over 45 years. So I think that's a basic problem in China. But we need to wait and watch what's happening with the Chinese economy for another 6 months before coming to any hard and fast conclusions, is what I would say.
I'm going to come to your article. In that, Raja, you write, UAE has offered to bring new and significant investments into Pakistan that could pull it out of the unending cycle of economic crisis and bailout packages. And India, which has seen a rapid transformation of bilateral relations with the UAE under PM Modi, might not be averse to seeing the UAE play a key role in promoting Pakistan's economic stability and making it a part of trade and investment flows between the Gulf and South Asia. Would India agree to this, Raja?
No, I mean, I think in any case, it's going to happen.
It's going to happen.
Yeah. So I think coming back to Imran Khan, I mean, and see, he really wrecked the economy too. So he went into the IMF. They, 22nd time or 23rd time. Now we're in the 24th version.
Which earlier, before he became PM, had said that he would not be like Nawaz Sharif or like Zardari. He would not go with a begging bowl to IMF.
So he went to them
and
then walked out halfway, saying that, look, this is too expensive. I don't want to do this because I don't want to incur the political costs of it. So that made it even worse because if they had stayed with the program by now, maybe they would have been in a better shape. So they pulled out. So I think the problem now is it's really the economy is in such a bad shape. Now they went back because the Nawaz Sharif people were also not very happy to go back to the IMF because for any politician, they say, look, why should I pay the costs? Because if you want to come back and win the elections, you don't want. But I think one reason why the army took over, I think, de facto in Pakistan, is to get the economy fixed, go back to the IMF, and now assembled a technocratic government which will do the necessary job. And here again, they have a long tradition of getting technocratic governments to do the bidding. But this time, I think what's happened, the difference which I was pointing out to was every time they were broke, they would go to Saudis, they would go to the Chinese, give me 1 billion, 2 billion, take 1 billion.
America too?
No, America won't give that kind of money. This is really the, Americans say go to IMF. But what happened with the Gulf is give me oil facility, free oil, deferred payment, 2 billion, 1 billion, and take 1 billion from you and I give it to Gautam because I'm indebted to both of you. So they were playing this game. I think the UAE, the sheikhs told them, look, don't come each time begging. Why don't you start selling your assets? I mean, the nicer word for it, privatization, asset monetization, we all use the economic jargon. They're saying, do reform.
No, to our viewers, just explain what the assets mean. You mean airports, ports?
For example, I mean, the Karachi port, total about 10 berths, they've just handed over to the Abu Dhabi Port Company. Islamabad airport is being privatized. So what they're saying is the strategy for the technocratic government is, look, and the army is taking a front role in this, which is to say they set up something called Special Investment Facilitation Council or something like that, committee, which was going to fast track, cut through all the bureaucratic stuff, no due diligence. We say, look, sell to the right bidders in a G2G contract, circumvent the procedure so that you generate the resources to manage the economy. Now, you can say this is a good strategy or not, but the fact is they've come to a point where the army thinks this is the only way to go forward. And in any case, and the Americans have told them, look, go to the IMF. IMF is also saying privatize. So the Gulf has the money. In fact, that's the point I was saying. Historically, we thought of the Gulf really as a labor market rather than today. The Gulf sovereign wealth funds have close to $5 trillion. Money they want to invest around the world. If you saw the newspapers today.
For privilege.
Not privilege, it's money to profit.
Yeah.
If this is a good investment, I just come to an example. Like today, there was news in the papers, in Indian papers. Qatari Sovereign Wealth Fund has invested almost 100 billion or something. I mean, for just getting 1% stake in Reliance retail stake, less than 0.99% stake, they're willing to put. So they have the money. They're looking to places to put the money. And like in India, Ambanis were in talks with.
And it's not as if Qatar and India have great relationship.
No, that doesn't. It's money.
It's just
really,
the money.
Yeah, it's money.
It's
like,
just
Either you go to New York or
not greenbacks. What is India's currency? What do you call it? Whatever.
So what are the 4 major financial centers? Right? You have New York, you have London, you have Hong Kong, you have now Shanghai, of course. So similarly, now Gulf has emerged as a place where there's money to be deployed because 40 years they've accumulated so much oil wealth. It is sitting in the banks and they're willing to put the money for profit. So I think that's where they have the capacity today. And so they've told these guys, Pakistanis, look, you start reforming, you sell your public sector assets, and we can put in the money so that long term you have actually a different strategy than going around with a begging ball, asking for money from everyone. The army seems to have bought into this line. This won't be popular because you basically, in India, you would say, look, handing over your
Crown
family jewels
yeah.
to foreigners without even due diligence. Like we're also privatizing. We're also, inviting FDI. But here is like wholesale handing over to foreign companies. But the fact is, if that's what they're going to do, I think that's where UAE, which has become very friendly to us.
To India.
Yeah, and the Saudis. I mean, if they kind of step into Pakistan, put some economic common sense into Pakistan's head, one is to get money. Other is to say, open up trade. I mean, anybody would have told them. It's not that Pakistanis themselves, Zardari government, Nawaz Sharif government, both they wanted to trade with India. Simple things across Punjab, between Lahore and Amritsar. I mean, they can get so many things much cheaper. But because of the, antipathy to India, they were not willing to do it. And the army finally changed under General Bajwa. But when 2021, remember, we had a ceasefire. After the ceasefire, we were supposed to start the trade. Well, army was for the trade. Imran Khan said no. So then I think that whole story ended there. But if anybody puts common sense into them, look, open your borders, import things from India so that you can benefit like other neighbors of India are benefiting. Be more reasonable to Afghanistan. So that's the kind of strategy. If Pakistan actually takes such sensible advice, we should not complain for that. If they open up for trade, because right now where we are with Pakistan, they say for anything you say normal common sense thing, they say no, first solve Kashmir. We're not willing to trade with you. We're not willing to sign any trade agreements with you. We're not willing to do even simplest things. They're not even willing to talk to you unless you reverse Article 370. But Delhi is not going to do that. So I think there is pressure on them to modify some of those positions. If that happens, we should say you're welcome. As long as you're ready to do business on a normal neighbor, India will be quite happy to do it.
So, Gautam, I want to come to you about two things from Raja's article and what he said. One, does it begin with pure commerce, and do they not want privileges as in political privileges, geopolitical privileges? Would UAE not want that? Two, is it a win-win situation if Pakistan's economy does well? Because, for a long time we used to hear that our neighbors should do well. If they do well, it's good for India. There's another opinion that when Pakistan does well, they attack us. So it's better that they are in the ruin. So there are two views about it. So tell me, what do you think?
No, I think I'll pick up on one thing that Raja said, which is that if some of these other countries, like the UAE or Saudi Arabia, are able to drill some common sense into Pakistan decision makers' heads, that will be something which will be welcomed in India. And the first common sense thing to do is to open trade, because that is simple. It's not going to be possible to solve a Kashmir issue or to, do something with Article 370, etc. That's much more difficult. The politics of it is going to be much more difficult. The easiest step is to trade. And I think if trade were to be open between India